Hearing in the appeal, Bergan and Evans.
Yes, Mr. Kelsick.
Good morning, my lord, my lords, my lady. I appear for the appellant. With me is Mr. Gareth Wilkin. For the respondent is Mr. James Guthrie, QC, and with him is Mrs. Angelina Sukubab. My lords, and my lady, I intend to deal with 5 issues this morning very briefly, and I do not expect I will take the entire 2 hours allotted to me.
We were rather hoping that, yes.
Probably not even half of that, my lord or my ladies. Those issues are briefly the relationship between Rule 32.72 and Section 163, the legal effect of a notice of objection not being given, the relevance of Section 163.
So this is the second point, is legal effect of notice.
Of the notice of objection not being given.
Under Section 163?
Yes, my lord. Yes.
Yes.
The third point would be the relevance of Section 163 being substantive law, yes, which is an issue relied on.
Those are all about Section 163?
Yes.
Yes.
The fourth is the scope of Rule 10.62, the scope. And the fifth, my lord, is the effect of non-compliance under Section 10.6 in not responding to the 8.6.
But, yes, well, obviously there's an issue under Section 163, which we would like to hear you about. But can you help me on the practicalities? It's rather a mystery to us, is what it seems that the Dr. Lawes' evidence was obviously important to the case, but for some reason an application to admit it was dismissed in March 2013. What was the objection to Dr. Lawes' evidence, and why was it not?
I was not privy to that application, my lord, but under the rules, the CPR expert evidence has to be sought, the right to call expert evidence.
Yes, I know, but here's a perfectly straightforward claim for injuries suffered alleged as a result of an accident. Whether or not your defence complied with the rules, you were making it clear, or your client was making it clear, that he wasn't admitting the injuries, and so they had to be proved, and the only way to prove them was to call Dr. Lewis. So what on earth was that objected to?
Yes, I can only infer, my lord, that it was based solely on the fact that it was not sought at the case management conference.
Maybe Mr. Guthrie could help.
Instructions on this, because it was
Yes, I think Ms. Sukubab was there, wasn't she?
Yes, she was there, and indeed it was the first question I asked her.
Yes.
Apparently there was a technical objection that the affidavit in support of the application to adduce expert evidence did not exhibit the doctor's curriculum. But the view was then taken, as I think you've probably seen from the papers, that an application under Rule 32 wasn't necessary in the first place because it had been exhibited to the state.
What? So if it, not on the basis of 163, but on the basis of because it was exhibited to the claim, therefore you didn't need...
In fact, I think that, I don't want to turn, but I think if you look at 10, 8, 9, 4, you'll see that the provision doesn't restrict the claimant to call other or additional evidence.
No.
It rather implies that you can...
Oh, look, we'll come on to that. Anyway, it was a purely technical objection, apparently. I see. Well, we'll see where we get to on that. Anyway, you take your own course, because on the certainly with the 163 point, and we'll see how much help we need on the other points.
Thank you, my lord. In relation to the first issue, my lord, Rule 32, Part 32 provides for the deployment of expert evidence. Under Rule 32.72, that evidence, under Rule 32.71, that evidence is to be in written form. However, Rule 32.72 provides that that is subject to any rules against hearsay. Now, my lords, in the absence, and my lady, in the absence of a provision, therefore, such as Section 163, all evidence given pursuant to Part 32 would have to be given orally because of Rule 32.72.
Which enactment is it referring to, restricting the rule of hearsay evidence?
I beg your pardon, my lord?
37.2 says the rule is subject to any enactment restricting the use of hearsay evidence. Which enactment are you founding on?
There is no enactment, my lord.
Well then,
But there is laws, obviously the common law, restricting hearsay.
but 32.72 makes it subject to any enactment restricting the use of hearsay, not subject to the common law.
Yes. My lord, I would answer that by saying that the rules do not purport to alter the laws of evidence. So I think that was really just a statement, perhaps unnecessary, that the operation of 32.71 is subject to existing law as to hearsay. But in any event, my lord, prior to 2011, when the Evidence Act was passed, there was an enactment that provided for the admission of hearsay evidence. And that enactment was replaced, and I refer to that in our written case as the UK regime. That enactment was replaced by Section 163 of 2011, because by Section 175 of the 2011 Act, the prior Evidence Act was repealed, and therefore the UK regime would have been repealed. So, in fact, my lord, it is perfectly permissible for Section 163 to be relied on to submit or tender written reports as contemplated by 32.71. And our submission, therefore, my lord, is that contrary to being a separate regime, as the courts below appear to have held, Section 163, in fact, plays a critical role in the administration of Part 32, in permitting and giving the mechanism for the tendering of written expert evidence. It is the means by which that particular rule can be satisfied. That is my brief submission on that.
Sorry, where does that take you then?
Well, where that takes me, my lord, is the courts below held that Section 163 is a separate regime,
yes,
operating separately.
Your position is that Section 163 deals with admissibility,
only.
doesn't override the ordinary requirement for you to get the consent of the court to the...
Yes, my lord. It deals solely with the issue of admissibility, leaving untouched the operation of Part 32, because in our submission, Part 32, by definition, must deal with evidence that is admissible under some substantive law.
I see that, I mean, Section 173 of the Evidence Act.
173, my lord?
Yes, on MS page 347, which provides for rules to be made for anything necessary for carrying out or giving effect to the Act. Have you got that, 347?
Yes. No rules have been...
No rules have been made specifically under the Evidence
No,
Act.
my lord. No.
And certainly, Rule 32 is not made under the Evidence Act. Is it?
Rule 32 was not purported to be made under the Civil Evidence Act.
Right.
As to the second issue, my lord, the nature of the notice of objection. In our submission, the notice of objection is of a purely formal nature. And the reason we say so is that there is no provision in the Evidence Act of 2011 that provides for the litigation, for lack of a better word, of any objection made to the tendering of a written report, which in our submission would show, therefore, that it is solely an indication of whether there is an objection to the form in which the evidence is being tendered. That is the written form. And it relates in no way to the contents of the written report, because objections to the contents of the written report would be based on rules of evidence, such as we've raised in our written case, whether it contains inadmissible hearsay and the like. Such an objection, my lord, cannot be the type of objection contemplated by Section 163, because such an objection would require a ruling of the court. And there is no machinery in Section 163 for such a resolution of an objection to take place. So in our submission, there is nothing whatsoever illogical in a party taking the position, when served with the Section 163 notice, that no, we do not object to the fact that it is in written form. That is not our objection. Our objection is it contains inadmissible evidence and the like, and those are objections that we will intend to take at trial. So we will not serve an objection because we do not object to the form of it, but we will reserve our substantial objections to be dealt with at the hearing, at which point we can get a ruling on those objections.
But is that consistent with effective case management if you reserve your objection to the substance of the report to the trial? Because if the expert evidence is a necessary part of the determination of the dispute, then raising it for the first time at trial without prior notice is hardly consistent with the overriding purposes of the rules.
The answer to that, my lord, is that in this case, that notice was served pursuant to an expert that was not indicated or permitted at case management. It occurred well after case management. And of course, we will submit that it ought to have been raised at case management, and for the very reason that your lordship indicated, when these issues could be ventilated. But if a party chooses to use a separate regime, which is what the courts below held, if it is in fact a separate regime and it can be deployed completely and separately to Part 32, then there is no need to comply in any form or fashion or raise the matter at the case management conference. So if it is indeed a separate regime and a party chooses to ignore the CPR or sidestep the CPR and serve a notice, then the position is, I would respectfully submit, as I indicated.
I'm still slightly confused about what this is all about. I mean, what Dr. Hendrickson's report, which we have at page 87 to 89, doesn't actually tell one very much more than one knows anyway, which is that she's alleging that the accident caused these injuries, and it confirms the sort of nature of the injuries and tells us that she needs to go to Trinidad or Barbados to have them dealt with. I mean, what was the problem about that evidence in substance?
The problem with this evidence, my lord, is that it is premised on Dr. Laws's evidence.
Yes, of course.
And if Dr. Laws's evidence is inadmissible.
Well, no, but she's got to prove her case.
Yes.
What I'm trying to understand is how, on your view, she ever gets to prove her case, because you object to Dr. Laws's evidence, you object to this evidence.
Well,
but we don't know where you stand on the medical issues.
I understand the court.
And here we are, 13 years on from the accident. We still don't know what. She still hasn't had her day in court.
The respondent, my lord, can apply at any point to call expert evidence.
But I mean, normally these things would be agreed, and the parties would take a sensible view, and we would get, the idea of all this finding its way to the Privy Council seems a bit bizarre.
But, my lord,
is there any, from your point of view, what is the practical objection to her calling Dr. Lewis, and if necessary, Dr. Hendrickson, to prove her case?
My lord, we simply would rely on Thomas J's ruling.
Yeah, I know, but the overriding objectives, the idea is to do justice.
I understand, my lord, but the principle, I understand the court's question, and I will deal with it, but the principles enunciated in the courts below do have.
Yes.
Do have.
No, I can see there is a point there, which is
there's a point of general importance.
Yes.
What is the relationship between Section 163 and the case management powers under the CPR? That is a matter of general importance.
Yes.
But in terms of this particular dispute, I mean, even if you were right, what is to prevent the claimant going back to the court and saying, Dr. Laws's report was refused on a technicality, namely that the affidavit didn't have a curriculum vitae. Here is a curriculum vitae. It's in the interest of justice that Dr. Laws's report, which has been available to the parties since the claim was initially made, be admitted in evidence. I mean, what possible objection could there be to that?
Probably, my lord, that such an application would be successful.
Yes.
But what I would submit is that in that application, though, we would be asking for the expert evidence regime under Part 32, because it gives us an opportunity to participate in that and to discover full information. But such an application, my lord, is likely to be successful, but no such application was made.
Sorry.
So we are here, my lord, because of the pronouncements made in the courts below on matters of general law, which have practical impact.
Yes, there is a general point,
Yes.
which is why we're here. But I was just wanting to see the.
I understand the court, and my lord, I don't think
but
that.
At the end of this case, whatever we say about the point of law, which I accept as a genuine point of law, I'd like to be clear that this case is going to get to trial as quickly as possible, or at least
This case will get to trial, my lord, and the delay. I appreciate the delay, but it took almost 3 years for the matter to be heard by the Court of Appeal, and for reasons which we are not aware of.
Yeah.
Yes.
All right. Right, so where we got to then on your scheme, we've looked at section 138.
Yes, and then I was on notice of objection, my lord.
And then, and you say the effect of an objection doesn't preclude you from taking the point at trial, even though that may not be very consistent with the general objectives. So where do you go from there?
Well,
just before you go on, can I just check I understood what you mean by your second point? I think you're saying that if an objection is given under section 163(2)(c)(2), that's it. It's objected to, so the evidence has to be deployed orally.
right,
The court can't override that objection.
correct, my lord.
Yes.
So the nature of the objection is not meant to address substantive issues of law as to the admissibility of, in relation to the contents.
Yeah.
So there's nothing illogical in not objecting to the contents, the form, I'm sorry, and reserving your right to object substantively at trial.
And the effect of that would be that the objector could cross-examine the deponent, because presumably the deponent would rely on his report as his evidence in chief. And
Well,
the objector could then take issue with it.
And the court, of course, has the power, but it is for the court to determine whether to call the witness.
Yeah.
So the party does not even have the guaranteed right of cross-examination without the court's permission. But what the party can do is direct the court's attention to the contents of the report and to make any objections that might be permissible to those contents at trial.
But if I've understood your case correctly, you shouldn't reach the point of just objecting at trial, because it should go through the Part 32
Absolutely, my lady.
process. And at that point, you say it won't do in this form because of the following aspects of the written evidence that we've seen.
Absolutely, my lady. But this argument is based solely on the ruling of the courts below. If, in case we're wrong,
Yes.
that it is a completely separate regime.
Right?
The third issue, my lord, is the issue of substantive law. What is the relevance of Section 163 being substantive law? Courts below, at least implicitly, held that if there is any inconsistency between Section 163 and Part 32, then Part 32 is displaced because Section 163 is substantive law. But, my lads and my lady, all rules of evidence are substantive law. So even if Section 163, if an objection is served, and the witness is required to give evidence orally, that evidence and the rules regulating that evidence are also substantive law. And there's no dispute, or there has been no dispute by the respondent, that Part 32 is effective to regulate that evidence governed by that substantive law. And in our submission, that such an argument would be tantamount to a submission that the Part 32 is, to the extent that it purports to regulate any evidence governed by substantive law, is ultra vires. Because if it is effective to regulate all testimony governed by substantive law, then it must be effective to regulate written evidence governed by substantive law, whether that substantive law is common law or statute. So, in our submission, it is not an answer to our argument to say that Section 163 is substantive law, because if Part 32 is effective in one instance in relation to common law, substantive common law, it should be effective in relation to substantive statutory law. And therefore, that argument in the courts below does not sustain scrutiny. Because, my lord, there has been no argument, my lords and my lady, there has been no argument that CPR, Part 32, is ultra vires. That has never been argued. Those are my brief submissions on that point. To the fourth issue, my lords and my lady, and this perhaps has even more practical effect and ramifications than the previous point in the practice in St. Kitts and Nevis. St. Kitts and Nevis have no pre-action protocols, such as exist in the United Kingdom. So a party faced with written medical reports attached to a statement of claim, who has had no opportunity to participate in the promulgation of those reports in any form or fashion, is simply not in a position to dispute the contents of that report if the party is not then prepared to admit them. The courts below, in particular the Court of Appeal, Justice Ramdani did not precisely indicate how he thought Rule 10.6 had not been complied with, appear to require a party to, in fact, do just that, to indicate the nature of the dispute that a defendant has to a report of which he or she may know nothing. And in our submission, a defendant can do no more than three things. He can admit the report, if he's prepared to do so. He cannot deny it blankly because the rules require him to say why. But he can deny it he can neither admit nor deny it because he does not know at this point.
And that general provision is set out in 10.53C.
Yes, my lord.
Yeah.
But that's the oddity, it seems to me, that you have that understandable provision in 10.53, and you don't have C in 10.62.
Yes, that is why it's the more difficult issue in practice in the jurisdiction, my lord.
Because one view might be that absent a pre-action protocol, then the defendant is placed in a situation where he or she will have to rely on Rule 20 to amend the statement of case at a later date.
And of course, my lord, like the applications for an expert, that must be done at a case management conference if one is able to do so in time.
As a general rule.
As a general rule, yes, of course.
Well, he could, in theory, ask for an extension of time to put his defence.
He can, but there is a limit.
He's got his own report.
Yes, there's a limit to the time that can be given
Yeah.
for such an extension.
Is there?
Yes.
But it is extremely odd that 10.53C has not been replicated in 10.6.
I was looking at 10.55, and it has slight vestiges of a mirror of 10.62. Admit or deny, say whether it's agreed or disputed. They're a bit similar. I don't know whether that tells us anything. Because again, in 10.55, the 10.3C provision isn't there.
It's not, my lady, and they do seem to cover much the same ground.
Yeah.
10.62 may be said to be a perfectly sensible provision, except for the requirement that you have to put it in with your defence.
It is an eminently sensible provision, my lord. If there was any form of pre-action protocol, it is eminently sensible. And we do not submit otherwise. And our simple argument is that until the defendant is armed with the information that enables him to do so, it is burdensome to require him to do so, because it really imposes on him an impossible task.
The question then arises as to what the consequences of this as well, because if you look at 10.7, you can't rely on something which could have been set out in the defence, and your argument is you can't set it out.
Can't set it out. And that provision is also oddly worded, my lady, because it seems on the face of it to relate only to a positive defence. It does not happily apply to 10.6, which is yet another oddity. And which is why I was hesitant to rely on that as the sole sanction for any non-compliance with 10.6. But in our submission, in any event, these are pleadings. And the purpose of pleadings is not the admission of evidence, of documents into evidence. It's the setting of the factual parameters on which the case is going to be disputed, or on which the case is going to be litigated. And 8.9 does no more than, notwithstanding that it requires the attachment of the reports, the purpose for that is to set the facts on record. It's not to tender the medical reports into evidence. And therefore, the only sanction, if there is one, would be to prohibit the defendant or prevent the defendant from denying the allegation of fact at trial. But of course, in this case, the respondent has at all times been aware that those facts were in dispute, and that would explain why she sought to get Dr. Law's call as an expert evidence, witness and the like. So the respondent in this case cannot say that she was not aware that those facts were in issue.
You said a moment ago that there were time limits on how much of an extension of time you could get for your defence.
I don't know if, yes, on page 312, my lord, bundle 1.
Yes? Here
10.37.
The maximum extension is 50. That's agreed.
Yes, yes.
That's an agreement which, if you like, takes the process out of the court's case management power.
You can apply to the court for an extension.
You can ask for more than 56 days,
yes.
presumably.
Yes.
Either because it's not agreed or because you need more than, exceptionally, you need more than 56 days.
Absolutely.
If your expert was overseas or something.
I thought the question was, my lord, whether the parties could agree to an extension. And they can, but there is a limit to which they can agree. Other than that, the court can grant further extensions, of course. The issue, of course, my lord, is even if you do get an extension, what happens within that time frame without any form of protocol, be it pre-action or otherwise? It would involve, of course, the claimant voluntarily submitting to an examination by a defendant's expert, and which would defeat, the entire rationale, in my view, such processes of having a Par 32 regime, which is to give the court direct control over the use and deployment of expert evidence.
Why would the claimant having to submit to voluntarily defeat the regime?
Oh, no. The claimant having to submit voluntarily will not in and of itself do so, no. But the parties, my lord, what in our view the Par 32 regime is intended to do is to vest in the court the control of expert evidence. Now, if the claimant, before a claim is filed, submitted to an independent expert, nothing is wrong with that, of course, as a step in negotiation. But once we've gotten into litigation, which we have here, the court wants to retain and has been given the authority to retain control over the use of expert evidence. But that is not a big issue on which we rely.
But it could be said that the court is hamstrung in its effective case management of a case where there's a dispute about the medical evidence if it doesn't know what the ambit of the dispute is.
Yes, yes. However, my lord, if a party has not been given the opportunity to know anything, the court then, I suppose the short answer is that the purpose of the expert and the function of the expert really would be to narrow any disputes about the medical condition of a party, because the expert is an independent expert. Both parties have the opportunity to question, and the result of the expert report is likely to, determine the matter. So it takes the dispute from a pleading issue, and it's resolved by a court-appointed independent expert. So in a sense, the dispute is resolved that way.
But in any event, the parties have an obligation to further the overriding objective.
At all times.
So that the court might, I suppose, think ill of a claimant who refused to permit the defendant's medical expert to examine her in circumstances where the defendant was seeking time to do that before pleading its full defence.
Yes. Yes, my lord, I agree. But if one was to adopt that approach, then we will have an expert that, in effect, was chosen by an expert who was chosen by the claimant. We will then have the defendant having to choose another expert and to seek the claimant's cooperation in having that second expert examined. And we will now have potentially 2 reports. However, when we get to case management, my lord, neither of those reports can be relied on unless the court so chooses. So the whole prior process might not actually further the overriding objective.
As I understand it, the application to rely on the evidence of Dr. Laws was rejected in March 2013.
Yes, it was.
At what stage did it become clear that the claimant was still intending to rely upon the evidence of Dr. Laws after that?
When the witness statements were filed and the claimant's witness statement had attached to them Dr. Laws' reports.
And when was that?
Check the case, man. If I can be given a moment.
That was back in August 2012, wasn't it?
The case management order, my lord, I guess we can infer from then, which is at MS page 53, page 54, I beg your pardon, paragraph 7 of the case management order indicated when the witness statements were supposed to be filed. And I do not believe they were filed.
So February 2013. So that was before the application to rely upon the evidence of Dr. Laws was dismissed.
Yes.
Well, my question is, when after that did it become clear, or do you say it was always clear from that point that they were still going to try and rely on Dr. Laws' evidence?
Well, my lord, how it transpired would be that after Dr. Laws' evidence was, after he was refused permission,
yes,
then it became a live issue, obviously, whether the reports attached to the claimant's witness statement were admissible. So one can say it became apparent when the application was dismissed to call Dr. Laws as an expert.
but it was apparent at that point that they were still going to seek to rely upon Dr. Laws' evidence.
There was no indication, my lord, but it had to be assumed
Right.
that they would do so.
So it was assumed.
Yes, it had to be assumed.
And yet, at no point between March 2013 and December 2013 did you indicate what any substantive objection to Dr. Lawes' evidence was,
That is correct.
despite the provisions of 10.6, of CPR 10.6.
Well, the defense would have been filed by then, my lord.
But the defence, does that...
The defense would have been filed in 2012.
The defence doesn't set out any detail of any objection to Dr. Lawes' evidence, though, does it?
No, my lord, but
But it does, more importantly, it doesn't make clear what your substantive case is on the medical.
Exactly.
the defense?
Yes.
Well, the defense, my lord, is we neither admit nor deny because we do not know.
I know that was what you were saying in
Yes.
2012, but by the time we get to the end of 2013, and you know they're going to rely on this evidence, surely it was incumbent upon you to say either we accept it or we don't accept it because we've got alternative medical evidence which says something different, or...
Well, at that point, my
Make
lord,
a substantive case.
at that point, our submission was that there was no admissible evidence. If, as the court asked earlier, whether an application, if made now, would be successful, of course, it can be resolved then. But the position is that at this point, at the point when the court is referring to, there was no admissible evidence.
But isn't that putting the cart before the horse? The purpose, as I think you accept, of 10.6 is to require issues about claimants' medical evidence, if they've annexed it to their pleading, to be sorted out in pleadings so that the parties and the court know what dispute, if any, there is about the expert evidence, about the medical condition of the claimant, which can then be made the subject of sensible directions for evidence. It's a bit odd to say, well, we didn't think we ever had to set out what our case was because they hadn't got any admissible evidence in.
No, my lord, that is not what I intended to say. That's how it came across. When the claim was filed, and the witness, the reports were attached to the statement of claim, at that point, the defendant had no means of disputing. That is when the defense, that is when 10.6 was engaged. That is when the defense was required to be filed. So all we are saying is that at the time the defense was filed, we could have done no more than say we neither admit nor deny because we don't know.
No, but you could have, given that the rule required you to take a position, unlike in 10.53, you could have said that you were not taking a position now and sought to reserve a right to expand your defence once you had obtained the necessary medical evidence. I mean, the ones say what they say. We can't get round them.
They say what they say, my lord. And
there is no subsection C or sub-rule C as there is in 10.5.3.
No. And I mean, the practical effect of them is to say to a defendant, you can't, in an injuries case of this kind, if the claimant's exhibited their medical report, just say, prove your case. You've got to get off your backside and work out what your answer to it is going to be and plead that answer. And then the court can see what, if any, evidence needs to be permitted.
If the regime panned out, my lord, and if I may, a defense is filed saying what we said in our defense, it goes to case management conference quite quickly thereafter. The claimant applies to call an expert because the defense is as it was. The court complies grants that application, and we now have an independently appointed expert to which both parties can address questions and that sort of thing. When that expert, my lord, issues his report, it addresses the matter.
Well, that would be so if the Part 32 application was for a single joint expert.
And that is very common.
Well, it may be very common, but I'm just looking at what the rules provide. And in a case where the claimant has actually annexed to his pleading the report of the person who is qualified to be an expert they want to use, I quite accept the court may overrule that under Part 32, but nobody made an application in this case for the appointment of a single joint expert, did they? It's just the claimant sought to get their Dr. Laws appointed.
Well, because the claimant is the one who has to prove the case, one would expect the claimant makes that application at the case management conference. But even if, my lord, there were 2 experts appointed at the case management conference, it still provides the opportunity for the process that is engaged in the UK in the pre-action protocol to be engaged under the CPR. And that, of course, would give the defendant the requisite knowledge.
I mean, might it be said that Justice Ramdani really had in mind that at no time between the service of your defence in October 2012 and the commencement of the trial in December 2013 did you give any indication of what your objection, if any, to Dr. Laws's evidence was?
I think Justice Ramdani, my lord, was taking issue more with the fact that any objections raised, such as we raised on the morning of the trial, should not await the trial. Not that we had an opportunity to engage 10.6, but he just appeared displeased that we raised any objections for the first time on the morning of the trial.
Well, he referred quite expressly in paragraph 32 of his judgment to 10.6.
Yes, because that was an issue, obviously, my lord. But it was just one of the objections that we had raised before him. I don't think he was trying to suggest that 10.6 could have been engaged at any time after the defense was filed.
You know, your position is that 10.6 is satisfied by what you did in this case, which was simply effectively putting her to proof. You're entitled to maintain that position up until trial.
Yes, my lord.
Right. Well, anything else then?
No, my lord. That covers.
Do you want to, I mean, the judge fairly described this as an ambush. Do you want to say anything about the way in which this was done at trial, which certainly we may want to comment on?
I can only say, my lord, that if I had had conduct of it, I would have not done it that way.
Would have done it that way.
That is all I can say. I personally would not have done it that way.
It has had the very unfortunate effect that this
but that is all I can say.
For 5 years.
Yes, sir. We do. Sorry.
No.
I appreciate that you weren't there at first instance, but we're being told that the objection to the admission of Dr. Law's evidence was the absence of a statement of qualification in the affidavit. Now, I just wanted to look at the substance of that. At MS 61, we have the application to call Dr. Mervyn Laws as an expert witness and produce a report. At 69, we have the affidavit of the claimant where she explains that Dr. Mervyn Laws has been her attending physician for most of her life and attended to her in relation to the injuries after the accident. And we have the reports starting at 73, where Dr. Mervyn Laws indicates that he has a Bachelor of Medicine and a Bachelor of Science from the University of the West Indies and is a general medical practitioner. And I have to ask, what more could be required?
Simply said, that's not good enough. The affidavit must itself state the
Yes. Right. There we are.
Yes.
There we are.
Like I said, my lord, I share the court's.
Yeah, well,
I do.
It does seem the case has been derailed at that point.
And what has happened, my lord, unfortunately, I accept that, is that it has led to, it then transpired a series of events that led to a ruling that has generally...
It has led to a ruling about the relationship between
Yes.
the CPR and the Evidence Act.
So it's unfortunate that the
is of
issue
general
arises in a case like this, my lord, but it perhaps was inevitable that it was going to arise. It's just unfortunate that this is the occasion on which it did so.
Right. Well, thank you very much. Anything else? Mr. Wilkin, do you want to? Right. Just...
My Lord, the respondent's position is that the difficulties which have been suggested are really manufactured. There is nothing in our submission troubling in the various we work together perfectly well. Concern. If one begins with one finds that in 8 and 9, which you Richards have on page 307, that for the first time, personal injury claims are, so to speak, according special treatment by the CPR. In our submission, it's a perfectly clear provision that requires the attachment of a medical report. Plainly, the intention is to bring matters to the fore sooner rather than later. And subparagraph 4, which I briefly mentioned at the stage, doesn't restrict the right of the claimant to call other additional medical evidence at the trial of the claim. It plainly indicates that it's anticipated that she will be calling the evidence as contained in the report. It is attached to the statement of claim, the evidence on which she relies.
Your position is that the 8-9 really overrides the requirement for leave under Rule 32.
Yes, in effect, it's a special provision, and I think it's an ordinary principle of construction that where the rules provide special or specific requirements in relation to a particular matter, then that specific requirement will be effective over any more general requirement. And one sees when one comes to 32 that it isn't really dealing with this situation, we would submit, at all. But we then find personal injury actions being expressly addressed in relation to the defence in 10.6.
Okay, just pausing there, I mean, what you're submitting is not the view taken by the Court of Appeal, is it? If we go to page 33, paragraph 12 of the leading judgment of the Chief Justice, where she looks at the relationship of 8, 9 and 32, the fact that the application was dismissed simply meant that Dr. Laws could not give expert evidence at the trial or produce an expert.
That I think, is just referring to the respondent's argument.
The respondent further argued, yes.
Yes, I see. She's not accepting.
No.
What was her position about the effect of...
I think it's the end of paragraph 17 on page 35, the last couple of sentences.
Yes. Yes. Well, that is our position. No derogation from the general provision as to expert evidence.
But is she saying that Rule 8.9 implicitly allows Dr. Laws to give evidence, regardless of whether
No.
leave is
I don't think she's saying it. I think we would say it because of subsection 4. Subsection 4.
But she says there's no derogation from Part 32.
But is this doing any more than specify what has to be pleaded? It says if you want to call a doctor, then you've got to put his evidence, his report, in your pleading, and then they have to plead to it.
But it would make it, in our respectful submission, inconsistent with the overriding objective if those rules are complied with, and then you have to make a separate application for expert evidence under 32.
It's what the claimant intends to do. That can be subject to the procedural management of the court. And in 4, it is the right of the claimant, but it's the right, if it exists, of the claimant to call other medical evidence.
Well, maybe I'm subsection 4 too. But it's a perfectly sensible provision which we complied with. And it should have been met by compliance with the perfectly sensible provision in 10.6, which would have enabled the court to know what the issues were. We would not accept that the requirement to comply with section 10.6 causes any particular difficulty. The report is not an independent expert's report, the report being there referred to. It's a report by the defendant, if he is to rely on it. As a matter of practicality, the defendant will have the statement of claim served on him with the medical report. He then has 28 days in which to consider the matter, and if he wishes, instruct an expert of his own, or a doctor of his own. The general 28-day period can be extended by agreement, and if the maximum time under agreement, or those 56 days is exceeded, or there's no agreement at all, then the defendant can apply to the court for an extension of time in which to obtain the evidence, the medical evidence. And one cannot imagine that in those circumstances he would not receive such an extension of time, provided he was acting reasonably. And one can also see that a claimant who failed to cooperate with examination which was sought in those circumstances would be likely to suffer as a result in the estimation of the court in due course.
Well, Rule 1.3 requires all parties to do what they can to serve the overriding objective.
Indeed, yes.
Can I just ask you this, Mr. Guthrie? Mr. Kelsick told us, and it sounds sensible to me, that in many small personal injury cases, the disputes about the medical aspect of the matter are dealt with by a single joint expert. So, and both parties then have the opportunity to question the expert. If Rule 8.9 overrides Part 32, how could the court control by the use of its important Part 32 power the case in such a way as to ensure that in an appropriate case, a dispute about the medical aspects of the matter was dealt with by a single joint expert rather than by a claimant insisting on calling his or her doctor and therefore the defendant having to call their separate expert as well?
Well, my Lord, the claimant must comply with 8.9.
Yes.
If it's not agreed, then of course there's the opportunity to apply for an expert under Rule 32, but there's no necessity to do that if defendant puts in his own report. In fact, I'm afraid I'm not sufficiently familiar with practice in St Kitts to know whether it's more likely to have a joint expert or to have a doctor from each side disagreeing with one another. Certainly that would be...
Well, it would...
I'm told it depends.
Wouldn't it depend? It would be a proportionality question. If it's a relatively modest claim, the court would be likely to encourage or insist on the use of a single joint expert. If it's a large claim, it may well think it appropriate to have an adversarial fight.
Well, I see that. But one assumes that in attempting to comply with the overriding objective, the parties are going to be necessary on any of these matters. It's management hearing. What I'm suggesting is that the rules under 8, 9 and 10.6 are not likely, in fact, to cause any difficulty at all. The consequences of not setting out the defence in 10.7 have to be read subject to the fact that the defendant has as much opportunity as he does have to put his position on the basis of his report. But the rules do appear to require which is to rely on one, and as I think your lordships have already observed, the rules are the rules.
But the judge seems to have thought, I think that's right, page 17, that if the defence fails to comply with the requirement of the issue is, then is debarred from taking any issue with the medical reports.
Well, that it would be our submission, because that would be the...
I didn't hear that.
That would comply with the overriding objective. I mean, if the purpose is to deal with these matters expeditiously and proportionately, and if the plaintiff complies with the rule, and the defendant does not indicate any objection or disagreement with it, and does not comply with 10.6, which is the important point, it's not good enough, plainly under 10.6, it's not good enough simply to not admit or deny, then the expeditious way of dealing with it is to say, well, you didn't join issue with the medical report which was served by the claim form, then that is that.
Yeah, I see. So, I mean, is this right? Your position is that Dr. Laws's reports having been attached to the statement of claim, that put them in evidence and indeed entitled the
only put them in the evidence if the defendant, as he didn't, as he failed to do, he didn't comply with 10.6. It would not have put them in evidence if he had indicated, in compliance with the specific terms of 10.6, what he objected to.
Yes. And then what
objected to in terms of admissibility, but what he disagreed with.
Yes. 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 Because if he, you have a report which says the man has broken ribs, and he simply says, well, we don't admit anything. But he doesn't comply with 10.6, which says, why don't you agree? Then the report, the plain intention of the rule in our submission is that that report will be admissible in evidence.
But on the judge's view, it's not merely admissible, but conclusive.
Well, it would be conclusive if there has been no objection raised to it in accordance with 10.6.
Subject to any other order of the judge?
Yes, subject to any other order of the judge. This is a perfectly sensible way of dealing with the matter, which is proportionate.
So even if it were treated as pleading, you say that in effect a failure to challenge means that the pleading is admitted, and therefore
exactly that.
Not
exactly
susceptible.
That.
It's not so much that the evidence is admissible, but if it's pleading,
yes, it's admitted.
As admitted,
yes,
and therefore not susceptible to proof at all.
But it's not necessary to call the doctor. No.
No.
Of course, either party or the judge or the defendant can apply to cross-examine. But what he ought to do, and didn't do in this case, was comply with the express requirements of 10.6.
I mean, he couldn't. Let me test this further. But how could he apply to cross-examine if he hasn't complied on your case with 10.6? Because the effect on your case of his non-compliance would be that the medical pleading, as it were, was admitted. And therefore,
Yes,
no proof
yes.
was required.
Well, I think I may have been, in my own mind, confusing this with what Section 163, which is has a similar, but that refers expressly to the possibility of the parties applying to the judge. But I would have thought that even if there had been a pleading error, there could be an application in any event for the doctor to be called. But the effect of the rules in our submission is simply that if the claimant complies with 8.9 and exhibits his report, but the defendant, as the courts found, expressly declines to respond in accordance with the rules under 10.6, then he is effectively bound by 10.7, because he's not allowed to rely on any allegation or factual argument which is not set out in his defence.
But the trouble is that leaves no room for I don't know, which covers both 10.6 and 10.7, because he's not necessarily going to know at that point.
He's going to have the opportunity to have his doctor examine the claimant.
When does he then say, and now that there's been another CT scan, I challenge the nature of the injury?
He can put in a further report.
Amend his defence.
He can amend his defence, whether that would, strictly speaking, be necessary or if a set of circumstances, I don't know. But
So what, in that situation where it depends on the reading of a CT scan, what does he say when he deals with 10.6.2?
well, he can amend his defence.
No, but when he originally puts in the defence, he gets the first claim form with the attached report of a CT scan which says there was this injury. He doesn't know if he agrees or not because he's not got his own report and it's technical
Well,
evidence.
he gets his report. He gets his report.
So he doesn't plead at all until he
what
gets
he
his
does,
report?
he has the statement of claim. He looks at his CPR and he looks at 10.6 and says, yes, I'm faced with a report and I've got to decide what to do with it. He says, I appreciate under the rules I've got to say whether all or any of it is agreed, and I've got to say if any part of it, what is the nature of the dispute with it. In order to do that, I need to get my own doctor's report. He gets his report. He has 28 days initially in which to do that. He can extend that period either by agreement or by application to the judge. He then exhibits the report to his defence. If the situation changes after that, he can rely on Section 163 apart from anything else. But what he doesn't have to do, I mean, he's in no difficulty. But if he doesn't, I mean, he can say in his the report which he intends to rely on, which he exhibits his defence, it is too early to say. So the doctor's report indicates I am not able to admit some particular aspect of the injury, but in due course a further report will be necessary. Well, that's a perfectly reasonable position to take on the pleadings.
Well, it's perfectly reasonable and perfectly understandable, but does it fit within 10.6.2?
Yes, because it does, because he's saying the medical report, he may say, the medical is agreed, save for a point which is not yet clear as to which the defendant reserves his position. There's nothing wrong with him doing that. But then he could not possibly be said to fall foul or to be debarred by 10.7, because he would have made his position clear in his defence and the report which was attached to it. And if the situation subsequently changes, then, among other things, he can rely on Section 163 and put in a report. Because the argument which was made, and I referred to briefly in the Court of Appeal, is that this was not in truth a situation which was envisaged by the general provisions in Part 32. It isn't necessary to bring Part 32 into this. And I rely on the principle that the specific provisions of 8.9 and 10.6, which apply to personal injury matters, prevail over the general provisions in relation to expert evidence, which appear more to envisage the calling of expert evidence in other circumstances. I mean, that's what we were saying to the Court of Appeal is recorded in that passage which my Lord Carnworth adverted to. In any case, the position is, if you like, the defendant is not prejudiced in any way by complying with 10.6. And similar specific provisions are made which can be applied at any point by Section 163 of the Act.
So we're now coming on to Section 163.
Yes, I was going to move on to 163 unless there was anything further.
So just before you leave 8.9 and 10.6, your submission is that if the claimant does what is called for by 8.9, there is no effective response in the defence, there is no need for the claimant to go to court under 32.6 and say, give me permission.
But it goes further. I mean, are you saying there's also no need for him to lead the evidence at all?
Well,
yes. Are you treating the medical report as amounting to pleadings which are treated as admitted?
Yeah.
And if so, is there any authority to support that interpretation?
Well, that was what the judge thought. I would respectfully submit that the judge was right to say that if the opportunity to admit or deny is not taken in the face of the specific provisions under 10.6, then the admission is to be inferred from the failure to comply with the rule.
I mean, the general rule is that a failure to plead a defence doesn't absolve the claimant from having to prove his case, although he may be able to do it in a fairly short and formal way, particularly if the rules contain a provision like 10.7, which effectively stops the defendant taking issue with factual matters.
It effectively stops him putting anything to the doctor.
Yeah, he can't raise factual arguments. Yeah. And I suppose you say that, well, arguments about the extent of somebody's injuries are factual matters, even though they're proved by expert evidence. Yes.
Still be open to the defendant to say, well, I appreciate I can't raise any factual argument against what is put against me in respect to the doctor's report, but that does not suffice to make good the claim.
Mm.
The short answer is that the purpose of the rules to 8.9 and 6 is to, so to speak, provide that it does. One looks at the purpose of 10.6, and the purpose of 10.6 is that the court will know if there's any dispute, and if there's not a dispute, it follows surely in accordance with.
As far as the medical evidence is concerned,
yes.
It's not a dispute.
Yes.
I understand that.
So the medical evidence, if it's not disputed, it's admitted.
Yes. I understand that submission, but it's still open to the defendant to say, notwithstanding that I'm not able to raise any factual argument in response to this case, nevertheless, the case as pleaded still not adequate to make out the claimant's case as a matter of law.
Well, I'm not sure that I see the reason behind that, because the claim has been stated, the witness will presume that the claimant will presumably go into the witness box and say...
So it's a matter of reality.
Yeah. The extraordinary thing about this case is that there have been all these objections to almost everything which could have been objected to. One of the objections being that Dr. Hendrickson is relying on a version of the accident which he has heard from Dr. Laws, when in the defence it's admitted that the defendant went into the back of the claimant's car.
Anyway, I mean, your general position is that once he's failed to comply with 10.6, then that's it, really, subject to any arguments he may have about the law or about the consequences of law. But can we move on then to section 163? Because I would like to be clear as to how this came in. I mean, as a matter of sort of history, it follows, from looking at the statement of facts, March 22nd, 2013, the response application is dismissed. That's in relation to Dr. Lewis. And then a month later, someone has the idea of putting in a report by Dr. Hendrickson under section 163. Was this a new idea?
Well, I think Dr.
Having been refused under...
Well, I don't think the refusal by Judge Thomas on the basis of the CV was regarded as conclusive.
Yeah, I see.
Well, we know that from the argument which was put before.
Because it was assumed that you could still bring it in under 8.9.
Yes.
But but if we go to Hendrickson's report, it's a slightly curious document because the substances that he really confirms Dr. Law's analysis. But at page 88, he goes, we have sort of 1 to 7.
Yeah.
Which, as far as I can see, are sort of calculated to sort of follow the section 38. For example, when he talks about 5, as mentioned before, mechanism of injury, he seems to think he has to go through. If you go to section 163 on page 345, it sets out the things which the report can cover under 1 to 7, 1 to 6, in fact.
Yes.
Dr. Hendrickson seems to think he has to go through them one by one, even though it's clear that he personally can't give evidence about most of them.
Well, I'm afraid I hadn't noticed the similarity between those items in the report and the subsections, but this was an additional medical report which the claimant wished to rely on, and she took advantage of section 163, which is again a specific provision.
Yes, but I mean, for example, take 6, the degree of force that was used with high energy. That seems to be a response to little 5 in 163, the degree of force that was used. But I mean, well, it's not terribly clear why Dr. Hendrickson thought it was a useful thing for him to comment on.
Well, I dare say he did have this in mind, but I suppose it would be for the judge to decide whether he wanted to pay any particular attention to that part of the report.
But I mean, the main point that he adds is that you have to go to Barbados and Trinidad, and it's going to cost $15,000 US. Yeah. Do we know whether she's had the treatment?
Not yet.
So she's still, while all this is going on, she's waiting to...
There seem to be 2 points that Dr. Hendrickson brought to the party. One was that this was a hyperextension rather than a hyperflexion injury, because the diagnosis, and he did examine the individual, what was cervical disc herniation at C6/7, and the opinion is that is consistent with whiplash injury, which is consistent with a blow behind. There's that, and then the second point is simply the cost of the procedure to alleviate the condition. Yeah. But the rest of it, you would say, the medical history prior to the examination at the bottom of page 87 is simply an expert recording from medical records or medical reports what has happened so far, which is very commonly done.
Exactly. All these reports are pretty typical of what one might expect to find.
Yes, indeed.
And there's obviously the additional complication in an island such as St. Kitts as to where the treatment can take place, because I think there was an earlier reference to the need to go to Puerto Rico. I'm told, and this is entirely a matter of anecdote, that one of the reasons for the passing of Section 163 of the Evidence Act was the small number of doctors in St Kitts and the reluctance of many of them, as indeed doctors often are reluctant, to go to court when they don't have to. So Section 163, which I think also exists in St Lucia, also exists in St Lucia as a matter of interest.
Yes.
Again, is a specific provision which relates to personal or to medical evidence generally. But it's quite clear, and again, it puts the defendant in no difficulty. It plainly does override the CPR because it says so in terms in the opening sentence, notwithstanding any enactment of law, and subject to the conditions specified in subsection 2, the following documents are admissible in evidence. And then it refers to the report having to be by a certified registered practitioner, etc. But we take issue with the observation of the appellants that the section, there's no mechanism whereby the defendant can, so to speak, challenge this. Because in subsection 4, it is expressly provided that notwithstanding the admissibility of the report by subsection 1, the court may, of its own motion or on application by any party to the proceedings, require a person who tendered a document in evidence under this section to attend before the court and give evidence. And the rather extraordinary thing in this case, well, I say extraordinary, but it's worth noting in this case that the judge had ordered the attendance of Dr. Hendrickson. And we see that, just get the reference. It is at page 16 in paragraph 30 of the judgment in first instance.
We don't have, do we have that order?
We don't have that order, I think. It's not included in the record, but he had done that. The section itself is quite clear because it says that the documents are admissible in evidence, but the defendant is protected by the possibility of an application to the court to call the concerned. Again, I make the same point. This is a specific provision dealing with medical certificates and reports and their admissibility, which must override the general provisions of Part 32 of the CPR.
Well, if 32 is about admissibility, I accept the proposition that it's an overriding provision, but it would only override something that was inconsistent with it.
Well, yes. Yes, I'm sorry. Yes, if necessary, I should have said.
Yes.
Yes, if necessary.
The point you've taken is, as I understand it, not that there isn't that overriding provision, but that there's just no inconsistency.
Yes,
between the
our
two.
principle is that all these provisions work perfectly sensibly and well together, and there's no reason to consider that they cause anybody any difficulty. They're there to assist the court to find out at the first possible opportunity what the disputes on the medical evidence are. The defendant is given every opportunity to raise a dispute, if he so wishes, under either the provisions of the CPR 8.9 and 10.6, or under Section 163. If he doesn't choose to do so, then there is no dispute, and the evidence is admissible.
In this case, the courts below took the view that 163 was enough to get the evidence in. If they were wrong on that, where does that leave us?
Well, look to see why they might have been wrong about that. I must confess to saying that it seems to be absolutely clear on the face of the section that they were...
Well, I know you're submitting that, but the other
Yes.
side is saying you're wrong, so we've always got to consider, I mean, if the truth of the matter is that 163 didn't get you over the need to apply under Rule 32, we don't have a decision of the courts below as to what the position would have been under 32, do we?
Well, if an application had to be made, presumably it had to be made, but so that's contrary to what we say.
I mean,
But you've already got an order from the court that Hendrickson will give him.
100%, yes. So
Yes.
not sure what more we need, really. I mean,
So even if it hasn't been a CPR 32 process, the court somewhere there is an order saying that he
Yes.
will give evidence.
Yes. Well,
I mean, all I'm concerned about, we don't leave any sort of loose ends. I mean, what you want is to be a position as a result of whatever we decide here on these tricky points of law, that we can get to a trial at which you would
Well, exactly.
call
I mean,
both Dr. Laws, insofar as necessary, and Dr. Hendrickson, or
Well,
rely on their evidence so far as necessary.
yes. Well, yes. Well, my poor client is in the position of having absolutely complied with the rules, and been faced in rather unsatisfactory circumstances with any number of objections. You've only been troubled with effectively.
Well, we've seen
Yes.
it all, yes. But I mean, your position presumably would be that if an application did have to be made under Rule 32, there would be no conceivable reason for not
There'd be no
granting.
conceivable reason to refuse it.
And indeed, the judge had already effectively...
Yes, indeed. Well, in effect of Dr. Hendrickson, he certainly had.
Yeah, all right.
But I mean, surely well, I say surely, the intention of Section 163 is to make medical evidence admissible, subject to the protection given to the defendant, that they can apply to the court
Yeah,
to have the witness called.
okay. Short point.
Can I-
Your Lordships have our written case, of course, in which looked all that.
Mr. Gaffer, can I just take you back to your earlier submission about the interaction of 10.7? And I think you say is if someone is meant to plead under 10.6 and doesn't, then under 10.7 he can't take issue.
Yeah.
Does that to make that effective, does one need to treat Part 32 as overridden? Why can't the claimant who is facing a defence which doesn't plead what he ought to plead, and where the defendant hasn't asked for an extension of time in which to have his own expert medically examine the claimant, why can't the court just say, well, I'm going to direct under Part 32 that Dr. Laws's reports stand as the claimant's medical evidence, and I'm not going to allow any cross-examination or any other material about it?
Well, the court could do that. The question, I suppose, is whether it's necessary for the court to do that.
Yes.
Because if I'm right in that 10.6 together provide for what should happen in a medical evidence claim, personal injury case, one doesn't need to go to 32 because, as an ordinary question of construction, the specific provisions of 8.9 and 10.6 will take precedence over the general provisions of 32. And if one looks at 32...
But that wouldn't it, effectively tie the court's hands in terms of what evidence it thought, exercising its case management powers, needed to be deployed to have an efficient and proportionate trial of such dispute as had arisen?
Well, there'll have been a case management hearing. So if the plaintiff was unwise enough to put about 12 different and inconsistent reports in front of attach them to his statement of claim, then the judge could make directions about that. Case management hearing, if he thought that the evidence ought to be presented in some other way, he could make some sensible provision direction under the CPR to make sure it didn't get out of hand.
Well, 10.7 gives the judge the opportunity to do that, because it specifically says unless the court gives permission or the parties agree.
Yeah. Mm. Yeah. Well, I'm not sure there's very much I can elaborate to know what the area of the
Thank you very
dispute. May I just, before I said, I know your lordships are, if your lordships are with us, we would ask for our costs in the appeal. It's often the habit or the course to invite further submissions. But I'm not sure in this case, I mean, obviously we would be able to do that, but it would potentially mean further delay. Sooner rather than later.
So, I mean, if we're not with you, where do you stand on costs then?
We would submit the merits of the case, even if there's something to be said about the rules, bearing in mind the judge rules. We shouldn't have delayed by that it was submitted to the Court of Appeal. The effect of 8, 9 and 10.6 was draconian.
Yeah.
Very unusual to find.
Well, they treat it as a point of great importance, they said so.
Well, they seem to have had no difficulty in resolving it.
But anyway, no, I'm really asking you, you say that if we're with you, then you should get your costs full stop. If we're against you on some of the legal points, then presumably you'll want to make submissions.
Perhaps I would want to make submissions in those circumstances.
Okay. Thank you very much. Ms. Suku-Bob, do you want to add anything? Right. Mr. Kelvin.
Just one very brief point. Mr. Guthrie suggested a clause that could have been included in the defense to comply with Rule 10.6, that the defendant reserves his position. I think it was Lord Hodge who questioned me about a similar wording, that you reserve your right to file a further defense along those lines. Neither of those, Malad, fall within 10.6. And in fact, the appellant used the wording available to him as prescribed by 10.5. So he actually utilized wording prescribed by the rules to indicate what I would respectfully submit is the very same notion. Because when you neither admit a matter, you are by definition reserving your rights.
But he did not thereafter, having reserved his right, exercise it by amending his defense.
And in fact, because well, I've submitted on that one.
Right. Thank you very much. Is that it?
Yes, that's it.
Anything else? Right. We're very grateful to all who contributed and for the succinct way in which you presented the cases. And we will take time to consider what advice we will humbly tender to Her Majesty. Thank you. Court is adjourned.